So just a little bit more about Myerson and Hayes. Myerson have supported in-house teams for many years, and we do have a number of our partners and solicitors who've worked in-house or been seconded to businesses like yours. So we do understand the challenges and needs of in-house counsel and teams. You should have the in-house materials on your chairs, or they will have been emailed to you, which detail our support offering. So whether you need assistance on a specific project, need support more regularly or on an ad hoc basis, or have a particular need in a specific area of work or sector, we'll be happy to help in a manner that works best for you and the business. Please do take a look at the brochure and reach out if you need any support or would like to discuss any aspect. Now passing you over to Oliver from Hayes to say a few words about Hayes.
Thank you, Keil. Appreciate that. Good morning, everybody, and thank you for the introduction. It's very good to be here. We're very delighted to be here partnering with Myerson in relation to this seminar and webinar. I'll be very brief, but just a few words about me and Hayes. So I'm Oliver Gibbon. I look after our Northwest legal recruitment team. I was saying to a few people here before when we were chatting, I started my career as a lawyer with Evershed Sutherland, as a real estate lawyer before moving into legal recruitment with Hayes 26 years ago. So I look after both in-house and private practice recruitment across the Northwest, recruiting at all levels from newly qualified through to and including partner level. Just a little bit about Hayes. We're a listed business operating nationally and internationally. But I suppose importantly, how can we help your business in terms of the in-house piece? Well, we provide permanent and interim recruitment solutions across the in-house and COSEC fields. This can be anywhere from sort of junior appointments through to heads of legal GC appointments. I thought it might be just worth talking about some of the added value services that we also provide, such as salary benchmarking. We provide insights in terms of industry reports through our What Workers Want report in terms of recruitment and retention strategies. And also we have a brand called Fairer Consulting, which can provide ED&I consultancy and training on those aspects. I did say I'd be brief, so thank you very much for listening. I shall hand over to the Myerson legal experts.
So I'll probably pass that over to you. Yes, sir.
Thank you very much.
There you
go. Thank you, Oliver. Thank you, Keil. And thank you all for joining us for today's session. In this part of the seminar, I will aim to provide a very brief overview of the legislative scene and outlook in the UK in 2025, mentioning some of the themes that will or may affect your businesses and organisations. I'll then take a look in a little more detail at some specific pieces of legislation mentioned on my slide. I've been asked to do some horizon scanning, so I've picked legislation that is either recently in force or is still working its way through Parliament. For many of your businesses, these may be significant pieces of legislation, so apologies in advance to anyone who is already familiar or possibly over-familiar with their provisions. To conclude my part of the seminar, I'll then discuss some recent cases with implications for the drafting and negotiation of common contract clauses. The current legislative scene in the UK is, to say the least, interesting. Our lawmakers, like everyone else, are grappling with issues raised by the growth of social media, artificial intelligence, and other disruptive technologies, and they do so against a backdrop of international turbulence. More time than I have available today would be needed for a discussion of socially important issues such as the measures contained in the Online Safety Act of 2023, the proposals in the Artificial Intelligence Regulation Bill, which has recently been kicked into the long grass of 2026, and the complex issues relating to copyright and AI raised by the Data Use and Access Bill. There will, however, be no shortage of legal and political commentary on those topics in the coming months and years. A significant piece of legislation affecting consumer law this year is the Digital Markets Competition and Consumers Act, or the DMCC Act, which I will discuss in more detail shortly. Data protection remains a key concern of government, so I will also talk in more detail about the Data Use and Access Bill and its European cousin, the EU's Data Act. For organisations which are subject to the public procurement regime, or which supply goods or services to such organisations, changes brought under the Procurement Act of 2023 have now come into force and will affect how procurement processes are run and contracts awarded. The DMCC Act is also key new legislation in respect of competition law. In particular, it introduces the strategic market status regime, affecting large digital platforms with substantial and entrenched market power in the UK, the Googles of this world. While all of these legislative developments are taking place, the UK's lawmakers are at the same time having to consider the extent to which our rules should diverge or align with those of the EU, which is a general theme across much of the UK's legislative agenda. So the Digital Markets Competition and Consumers Act is a substantial and multifaceted piece of legislation, as I say. If we focus on the consumer protection aspects of the Act, which may be of most immediate relevance, there will be a range of updates which may affect your business. Much of this consolidates existing guidance and case law, but much is also new and will require assessment. As ever in consumer law, achieving compliance in practice is likely to require close cooperation between the legal advisor and the client, whether in-house or external. A significant change is that the Competition and Markets Authority will now have direct enforcement powers, allowing it in its own right, rather than through the courts, to impose fines and a wide range of consumer redress measures for breaches of consumer protection laws. Guidance from the CMA issued earlier this year stressed that their objectives will include helping businesses to understand the conduct that is unacceptable and to know that their competitors are playing by the same rules. I'd expect that greater clarity and consistency in this space may be welcome to you and the business stakeholders you work with. It remains to be seen how much more active the CMA will become in using its new powers to create a level playing field. The DMCC Act also updates the consumer protection regime that was previously governed by the Consumer Protection from Unfair Trading regulations. The new rules include bans on the use of certain practices which are identified as in all circumstances unfair. These include bait and switch advertising, advertising one product and then when the consumer expresses an interest, starting to try to sell them a different product, more expensive. They also include bans on publishing fake or misleading reviews, among a host of others. And secondary legislation may be used to add new banned practices to this list from time to time. The DMCC Act makes specific provisions on a range of other discrete topics, for example, subscription contracts, automatically recurring contracts for the supply of goods or services, where the pre-contract information requirements will change, consumer saving schemes, such as Christmas saving clubs, which are not currently covered by the Financial Services Compensation Scheme, and the organisations that operate them will now need to protect consumer payments against their own insolvency through trust arrangements or insurance. And also the regime governing alternative dispute resolution for consumer disputes, where updates include the requirement for any entity which offers consumer ADR services to have been accredited in accordance with the requirements of the Act. There's much more that could be said about this complex piece of legislation. For the time being, I'll leave it there, but we'd always be happy to discuss any further questions you might have about how it affects your business. The Data Use and Access Bill is a long-awaited piece of legislation aimed at reforming the UK's data protection and privacy framework to reduce the burden on UK organisations. Its predecessor under the previous Conservative government was the Data Protection and Digital Information Bill, which was then reintroduced in Labour's King's Speech as the Digital Information and Smart Data Bill. The range of names by which this has been known is in part testimony to the challenges faced by successive governments in getting it through. The bill aims to harness the power of data to drive economic growth, and its proposals include potentially exciting developments such as the introduction of smart data schemes to encourage the secure sharing of customer and business data, the creation of a regulatory framework for digital verification, and the establishment of the National Underground Asset Register to map the location of utility pipes, cabling and similar underground apparatus. As well as those broader introductions, it also contains a very detailed set of adjustments to the UK's data protection regime. These include changes to the rules governing use of personal data for scientific research purpose, which is intended to facilitate such usage. And doubtless that's an area for those of you operating in that space which we'll already have assessed. There's clarification of what qualifies as legitimate interest for the purpose of data processing through the introduction of a non-exhaustive list of examples, which include direct marketing, intra-group transmissions of personal data for internal administrative purposes, and processing for purposes of ensuring the security of network and information systems, all of which may be quite helpful for purposes of putting together your basis for legitimate processing. And there's also a new approach to international data transfers. Some of the more contentious aspects of the old Data Protection and Digital Information Bill, as originally proposed by the Conservatives, have now been omitted. For example, there were proposals to replace the Data Protection Officer role with that of a senior responsible individual, and a reduction in the number of organisations that would have had to have somebody in such a role. That's fallen away. Likewise, for another example, in respect of proposed changes to the rules on data subject access requests. The point at which an organisation could refuse a data subject's access request would have been changed so that the request could be refused if it was vexatious or excessive, rather than the GDPR's higher standard of manifestly unfounded or excessive. And examples of vexatious requests included those which were intended to cause distress or were made in bad faith. Depending on one's views of the general merits of data subject access requests, this omission will be either welcomed or rude. But significantly, the changes in the contents of the bill do leave the UK regime in closer alignment with that of the EU. And this may well help the UK to maintain the benefits of the EU's adequacy decision, which permits the transfer of personal data from the EU to the UK under the GDPR. Currently running until 27th of June of this month. But potentially being extended to the end of the year. More briefly, I'll note that while the UK has been deciding how it will modernise its data regime, the EU enacted Regulation 2023-2854, or the Data Act for short, and this introduced new rules in respect to the use of data, covering both personal and non-personal data in this context, for issues such as access to and sharing of data generated by the Internet of Things, and restrictions on reuse of that kind of data, business-to-business and business-to-government data sharing, and the interoperability of cloud services. UK businesses will be subject to the EU's Data Act in a range of circumstances, including where they manufacture connected products which are placed on the market in the EU. And businesses should continue to monitor developments in that area. The EU Commission intends to issue recommended model contractual terms on data access, for example, which are designed to assist affected businesses. Another long-awaited piece of UK legislation, currently going through its third reading in the House of Commons, is the Product Regulation and Metrology Bill, which I'm always slightly disappointed to realise has nothing to do with weather forecasting. Again, this is an ambitious bill. It's intended to reform the product safety regime in the UK. This is necessary in large part on account of the understandable failure of legislation enacted over 20 years ago, including the General Product Safety Regulations of 2005, to deal adequately with new technologies and new online platforms and how they've changed the types of products available on the market and the manner in which they're distributed. And again, it has taken a long time to get to this point, with the UK's Office for Product Safety and Standards publishing the outcomes of their investigation into reform back in November 2021. When the Product Regulation and Metrology Bill comes into effect, that will not be the end of the horizon scanning required for businesses putting products on the market in the UK. This is because, if implemented in its current form, the Act will be a high-level piece of enabling legislation, rather than a detailed statement of new requirements. It will empower the Secretary of State to make further product regulations in order to reduce or mitigate the risks presented by products in the UK. Which means that the detail of the new regime, as it applies to specific products, will remain to be confirmed through secondary legislation. Those secondary legislation, the regulations, will in due course set out product requirements, which will cover areas including how the product is manufactured or produced, its components, including software and other characteristics, and how the product is marketed, including where it is marketed through an online marketplace, addressing some of the weaknesses in the current system. The regulations may also provide that a product requirement is met if a requirement of relevant EU law specified in the product regulations is met. And that's designed to allow the UK to continue to recognise the EU's CE marking, avoiding issues for businesses that look to put the same products on the market in the UK and the EU without going through separate conformity assessments, as the two products' safety regimes increasingly diverge. My final slides turn from legislation to case law, and very briefly summarise some recent decisions which may have implications for contract drafting and negotiation. Toppleson was a 2024 Court of Appeal decision, which included an analysis of, on the face of it, a fairly simple liability cap provision. The total liability of either party to the other under this agreement shall be limited in aggregate for all claims, no matter how arising, to the amount of €5 million. The questions referred for appeal included whether the cap needed to be applied before or after each party's claims against each other had been set off. And this mattered because the value of Rolls-Royce's claim was substantially greater than the €5 million cap, so much so that the value of Toppleson's claim could be set off against it and still leave Rolls-Royce with an entitlement to damages greater in value than the cap. This resulted in an award at first instance of damages of €5 million, that is, the value of the cap. However, if the cap was applied before setting off the two claims against each other, the value of Rolls-Royce's claim would be capped at €5 million, with the subsequent setting off of Toppleson's claim bringing its entitlement down to around €4.2 million. The Court of Appeal agreed with the latter interpretation, finding that in the absence of any wording to the contrary, the cap on liability should be applied to each party's liability separately before calculating any set-off. This view in there was supported by the fact that the wording of the liability cap referred to total liability and not net liability. From a drafting perspective, it's worth noting the decision and considering when drafting or negotiating a liability cap whether this is the desired treatment of counterclaim sums. For the party that is more likely to be the primary claimant, the risk of their claim being watered down by a counterclaim may be sufficiently concerning to make it worthwhile to introduce some relatively non-standard drafting. If so, the liability cap clause could state expressly that it will limit each party's net liability to the other and take effect only after any relevant set-off has been calculated and applied. At Costco, there was a High Court decision and dealt with a question that I find does get raised from time to time by clients as they are led reluctantly through the thickets of the liability cap clause. In this case, the cap was expressed as 5 times the service charge paid in the prior year and is applied in respect of all acts, omissions, events and occurrences, whether arising out of any tortious act, breach of contract or statutory duty or otherwise arising. The question at issue was whether the customer could rely on this cap as a total defence to the supplier's claims for certain historic unpaid invoices. Since because of the way the contract had run, the value of the service charge in the relevant prior years was in fact zero. Agreeing with the supplier's appeal, however, the High Court held that breach of contract in this context did not apply to a failure to pay for goods received. This was based on the analysis that the cap was intended to apply to the secondary liability to pay damages for breach, but not apply to a primary payment obligation itself. They considered the wording "or otherwise arising" from the clause, but concluded this was not sufficiently clear to rebut the presumption that the parties would want primary payment obligations to remain unaffected by a contractual cap. Although this interpretation does tend to align with how clients, particularly on the supply side, would expect the liability cap to operate in this scenario, our preferred drafting approach remains to state expressly that payment obligations are not subject to the cap, if that is the intention. A separate issue raised by the primary and secondary obligation distinction is whether a payment obligation under an indemnity would be subject to a general cap on contractual liability. Again, our preferred drafting on that is to address the question with express wording, stating as applicable whether the cap applies to indemnity claims or not. City Fibre concerned interpretation of a notice clause and how it interacted with good faith provisions in related clauses. The good faith provisions oblige the party wishing to serve the notice to engage and cooperate with the recipient of the notice constructively and in good faith, using reasonable endeavours to mitigate the impact of various matters, including those related to the notice. The notices in question were ones which CGI could serve on City Fibre from time to time, requiring City Fibre to vacate certain of the locations from which it operated its network services in connection with the contract, and to do so on not less than 3 months' notice. The court acknowledged City Fibre's argument that serving a mere 3 months' notice, while it would technically satisfy the requirements of being not less than 3 months' notice, would not be consistent with the requirement for constructive engagement and cooperation. This was because the technical issues raised by ceasing to provide telecom services from the relevant locations and management of arrangement with landlords and similar challenges meant this wasn't feasible in some cases. On that basis, the court concluded that the minimum length of the notice required at any particular location could not be less than 3 months, but could, in fact, on a case-specific basis, be a longer minimum period to take into account the practical issues relevant to the specific sites. In such circumstances, and taking into account the interaction of the relevant clauses, the notice requirements could not be satisfied in all cases by a mere 3 months' notice, notwithstanding the wording of the notice clause itself. In the RTI case, a UK Supreme Court decision, the contract required the customer to make payments in US dollars. However, US sanctions, treated in this case as a force majeure event, effectively prevented the customer from paying the supplier in that currency. The customer therefore offered to pay in euros and to compensate the supplier for the additional costs of converting euros to US dollars. The supplier refused this proposal and relied upon the force majeure provision to suspend its supply obligations. The basic question considered by the courts was whether it had been entitled to do so, or whether the customer's offer of an alternative workaround meant that the supplier could not rely on the benefit of the force majeure clause. The Supreme Court eventually found in favour of the supplier, stating that while the customer's proposed solution was logical, since the contract did not allow for flexibility over the currency of payments, the supplier was not obliged to accept a different method of contractual performance in order to overcome the effects of the force majeure event. From a drafting perspective, this is another example of force majeure clauses being subject to strict interpretation, arguing for greater thoroughness in attempting to ensure that these clauses deal expressly with how their provisions will apply in different potential scenarios. Two final cases relate to interest on late payments. Hussein concerned a loan agreement where one rate of interest applied while the loan was not in default and a different rate applied after default. Initially, the High Court determined that the default interest provision was void as a penalty because of the rate. Accordingly, it severed the void provision from the contract and awarded contractual interest after default at the lower pre-default rate. The Court of Appeal, however, disagreed with that approach and actually set aside the award of interest after default in its entirety, on the basis that, since the default rate was void and the pre-default rate only applied before the occurrence of default, there was no contractual entitlement for the lender to interest following default. Parties entering into commercial loans as the lender should consider moderating their requests in respect of default interest, noting the risk that a pre-default rate of interest will not necessarily apply if the default rate is held to be a penalty. Lastly, in Tata Consultancy Services, the courts have found that a contract which expressly imposed interest on undisputed sums at the Late Payments Act rate, but was silent on the issue of interest on disputed sums, had the effect of preventing the supplier from claiming interest at any rate on the disputed sums. The supplier had argued unsuccessfully that this reading meant there was no substantial remedy for late payments. However, the court considered that although the contract gave no remedy for late payments of disputed sums, it did provide a substantial remedy for late payments overall. That decision is subject to appeal to the Court of Appeal, And in the meantime, subject to the Court of Appeal's judgment on the measure, parties should review the terms of proposed contracts in respect of interest on undisputed debts and ensure that these provisions reflect the parties' intentions. As I say, this has been only a selective summary of legislative developments and case law updates, which I hope has been of interest. Time hasn't allowed for a particularly deep dive, so I'll end my part of the seminar with a plug for our blogs, which do go into much more detail, and for next month's tech seminar, described on the board, which will take place on 8th of July. We'll be working with our litigation team to discuss a selection of the most commonly negotiated and litigated provisions in tech contracts, from termination clauses to SLAs. And we're hoping that the seminar will be of interest to anyone involved in the development, management, or negotiation of tech contracts. That brings my part of the seminar to a conclusion. So at this point, I will hand over to Sven, partner in our litigation team, to discuss the do's and don'ts of litigation.
Morning all, and those of you online. As Richard explained, I'm a partner in the commercial litigation team, and you'll have seen my nauseating photo at the beginning. Very glassy and tanned for some reason, I don't know why. I've been asked to, bear with me, this is the first time I've been trusted with this clicker. There we go. So I've been asked to talk to you today regarding litigation process, do's and don'ts from inception. Unfortunately, by inception, we don't mean the film, we mean the onset of litigation, sadly. Now, so far as litigation is concerned, it can obviously come in many guises, take many forms. Arbitration, adjudication, obviously our common garden variety litigation, court proceedings of the sort that we do in the department. Now, while there are often common threads or points which arise in disputes, the reality is no one size fits all. To the contrary, while two cases might share identical sets of facts, the outcomes can be very different, depending on a number of circumstances and factors, not least parties' attitudes to risk. As in-house lawyers, obviously you will know that you stand there essentially at the coalface in terms of legal strategy and business execution, meaning that when litigation is contemplated, your position is pivotal. You're often having to sort of mediate on a daily basis, I expect, in terms of different teams, individuals within those teams, all of whom will have competing ideas and agendas and objectives. What we can probably agree no matter is that litigation is expensive, it's time consuming, it's unwelcome, can be a distraction to the business lasting months, if not years, until resolution. And if external lawyers are instructed, it's probably not because that isn't the course of last resort and not because you haven't sought at every level to try and avoid getting to that point. Though we at Myerson were obviously experienced and I think we're good at what we do, the reality is that external lawyers are expensive. We sometimes ask basic questions. We sometimes ask basic questions again and again because we didn't get it the first or the second time. We sometimes ask for things at the last minute. We sometimes, worse still, ask for things on a Friday afternoon, for which we apologise, but we really do need that information. We interrogate, we seem pedantic, we might ask questions which seem obvious. Whilst we're also collaborative and focused in terms of getting sort of the best outcome for you and the business, we are a burden. We're often inconvenienced, we know we are, and we're commonly described as a distressed commodity, well, I suspect we're called far worse. The question, therefore, is how best or better to manage litigation process and what steps you can take either before instructing external lawyers or without having to use us at all. Assume you can't avoid instructing us in some capacity or litigation in general, how best then to handle matters and hopefully make the process a little less painful. Certainly when litigation is contemplated, in-house lawyers will play a crucial strategic and operational role. And so in that scenario, while no way is it exhaustive, and given time limitations that Richard has mentioned before, I've distilled what I consider are some important things to think about. Now, it's not lost on me, we're obviously a lot of people in this room, a lot of in-house lawyers, all of whom will have their own sort of ideas, receive wisdom on the basis of experience. And whilst time doesn't allow us to get into a big old discussion, if there's anything that I raise you want to talk about, if there are any sort of do's and don'ts which occur to you, raise your hand. I'm quite happy to open the forum and have a discussion. Otherwise, we can pick up, obviously, questions at the back end. First click. Here we go. There we go. Early case assessment. Right. First up, obviously, before taking any major steps, it's vital to get a handle on the commercial merits. What are the chances of success? What is the potential damage? How much will it cost? Is that cost worth bearing? Not only in terms of finance, in terms of the overall resources. Are we genuinely at risk, or is this saber rattling by the other side? What are the consequences of doing nothing? And how does obviously that dispute fit within the overall business strategy? Realistically, the sooner the business completes this exercise, the better. It can then decide at that point as to what the terms of the response are, whether it wants to fight the claim, whether or not it's pushing for settlement, or for that matter, does it need to have to think about pulling in more expertise in order to bottom off the position. So with that, and as I said, unfortunately, they're all listed there. So if you would suspend your disbelief as I crunch through these, I'd be grateful. In terms of practical steps, obviously importantly, gather the facts, compile key documents, communications, and data that's relevant to the case as soon as possible. Second point, obviously conduct a risk analysis, assess the legal and financial risk of litigation, potential reputational damage created by the litigation, and how that can be sort of managed and mitigated. Third point, slightly self-serving, but consult with external lawyers if necessary, get early opinion on the strengths and weaknesses. Fourth one, make a preliminary decision. As I said, while the general landscape may change as the matter progresses, decide whether litigation is in fact worth pursuing, or whether or not settlement or some form of ADR, alternative dispute resolution, might actually achieve a better outcome. And the last one is, obviously, while circumstances may require an urgent response or a court filing for that matter, lots of value in taking a breath, or what some describe as the power of the pause. At this point, I was going to pause, you were going to laugh. There we go, thank you. That's killing it online, by the way. Overly aggressively responses can rarely achieve their purpose and can sometimes serve to entrench parties in their positions. Lawyers, just like their clients, have egos. We have to manage, we have to massage those on occasion, and where appropriate, you give them an out. If you go in far too bullishly, as I said, you can entrench, and therein lies an even greater dispute. Similarly, on the other side, an overly conciliatory response, or which is unduly passive, can have a similar effect and also be harmful because it emboldens your opponent's view on prospects. Importantly, and again, I'm conscious of addressing a room and teaching them how to suck eggs, but obviously at all times be conscious any correspondence that you send may well be read by a court at a later date. And so whilst your response may be withering, cutting, and terribly clever, just bear that in mind. There we go. It makes you wait, doesn't it? Preservation of evidence. Obviously, as soon as litigation is contemplated, you must take urgent steps to ensure that you preserve all relevant documents. Failing to do so may result in sanction, certainly by the court, or at the very least, it cuts you at your knees in terms of credibility at a later point. So in terms of the practical steps, obviously issue legal hold notices immediately to relevant employees and departments, instructing them not to delete or alter documents or data. For that matter, they should be cautioned not to create any other documents, certainly in the course of litigation, which may prove harmful. Those may well be disclosed at a later date, and that would be an unfortunate conversation then to have with your external lawyers. Obviously, internal communications in a similar vein about the dispute should be limited and controlled. as part of an overall brief to avoid speculation or discussion regarding sensitive matters or merits of the case. Obviously, that extends to emails or any sort of platforms, whether it's Teams or WhatsApp messages. On that point, obviously a part of audit retention policies obviously ensure that all potentially relevant materials are included in that hold notice, and obviously keep an eye on that because that will change as work evolves. The next one is slightly contentious: work with your IT department. Obviously ensure key documents preserved, including emails, files, and any electronically stored data. Your IT team should be best placed to advise, but obviously if they can't or you don't have the benefit of an IT team, consider engaging externals to assist with that process. Obviously, historic emails can be routinely deleted, and obviously the courts may later require you to confirm when those automatic deletion processes were stopped. And again, if you haven't done so and lose documents in that process, even inadvertently, that would be incredibly unfortunate. Next one, obviously, consider e-disclosure. Now, I don't obviously work for an e-disclosure company, and it's often regarded as an overthought, not only by us as external lawyers, but generally. But actually, there can be a lot of value in just engaging e-disclosure company early doors, preserving that data. Now, that will represent, there's no getting away from it, an upfront cost. And obviously that will be needs to sort of weighed up as a part of any cost-benefit analysis. But certainly, often legal proceedings take time, and it may be many months, if not far longer, before data is collected. And obviously then this prevents any inadvertent loss of documents. Preserving and collecting data can also assist with completing cost budgets and forming a strategy for any future case management conference. Running keywords, which is something we're obviously required to do as a part of disclosure. It's good to get on top of those and understand that if you apply a keyword now, what that's actually going to produce in terms of the data. And it could well save you a lot of time and man hours. And actually doing that process can help understand actual data sizes, because people don't really understand until they're in the process of doing disclosure just how big the data set is. And that's even before you start playing around with the various sort of special tools that are available, some of which sentiment analysis, and this highlights sentences from the documents, applies a sentiment score to how positive or negative it is. Rationale being the higher the negative sentiment, the more likely it is to be relevant, since it demonstrates that there's some contentious issues in discussion. Again, particularly useful in interrogating email data. Document summarization, ability to summarize documents or email threads you're looking at, get some more insight before taking a deeper dive. Again, that's particularly good where you're looking at documents which run to hundreds of pages. Chatbot functionality, I've not tried this one, but apparently the ability to ask prompts or questions, whether it's a single document, a folder of documents, the entire data itself. So it's obviously all rather clever, and those tools are out there. And as I said, it's always a good idea to consider those. And again, whilst I'm not here to talk about sort of legal technology or AI and what that means, but the reality is that it is going to come increasing to the fore, and it'll give you in-house lawyers, it'll give us external lawyers a lot of advantages. But as I said, that's for another day. There we go. Right. Asserting and obviously maintaining privilege and confidentiality is probably a classic challenge for in-house lawyers. Obviously, not everything said or done during litigation attracts privilege, and obviously a breach can obviously lead not only to loss of protection, but also reputational harm. Though the question of whether communications are subject to legal advice or litigation advice privilege could fill an entire seminar. Obviously, by way of a quick recap, and again, I apologise because this will be something that's very familiar to you all. Obviously, legal advice privilege attaches or applies to communications between a client and their lawyers, whether internal or external, made obviously for the dominant purpose of seeking or giving legal advice. Whereas litigation privilege, as the name would suggest, is in reasonable contemplation that the document or communication was created for the sole or dominant purposes of that litigation. Though litigation privilege does not cover commercial discussions if closely linked, and obviously there's a lot of interesting case law around that point. Unlike legal advice privilege, it does enable the client or the lawyer in this circumstance to communicate with third parties. Obviously, on the other hand, legal advice is a lot broader in scope and applies communications not only between client and lawyer, but also may relate to contentious and non-contentious work. And again, a quick sort of run through, obviously the first point, education. Educate employees on legal privilege and confidentiality requirements, particularly those who may be involved. Appropriately mark communications, obviously ensure communications where possible are appropriately marked to preserve privilege, whether that's marking them as subject to litigation privilege or in contemplation of privilege, litigation rather, that's something that should be considered. Though with all things, obviously, just because it says it is doesn't mean it is. And obviously, a common example of this is in terms of without prejudice communications, which people often think achieves protections where there are none without a genuine attempt at settlement. And then the last one, obviously, securing communication channels, obviously ensuring privileged information is not inadvertently shared or is accessible. Though the background may be widely known by a company and the organisation as a whole, there's obviously be certain commercial issues which senior management or exec team would rather was not accessible or available to staff. There we go. Right, settlement. Not all cases need to go to court. In fact, most don't, and thankfully do not. Obviously, part of our role is always to evaluate settlement and the strategic value of settlement, whether it's early during the proceedings or preferably not at the steps of the court. Despite appearances, and this is where we touch upon sort of question of ego, settlement is not a sign of weakness. It's often a sign of good judgment and de-risking the threats associated with litigation, but it has to be done carefully. It'll obviously require input from the business along with other considerations with an eye to what that says about the business and setting any future precedent. Obviously done well, it could be practical and cost effective and certainly the best of all options. Again, as regards settlement and possibly obvious, evaluate settlement offers or options. Considered early in the case, consider whether or not to make an early settlement offer to put the other side under pressure on costs, whether that's in the form of a Part 36 offer for those familiar with the civil procedure rules, or whether it is an offer expressed to be subject to, or save us costs rather, something that you should think about. But obviously, at all times, settlement should remain in your thoughts, particularly as new developments arise and the claim progresses. And for that matter, if you made that early offer and that offer hasn't gone away, think about withdrawing it if it's no longer attractive to you to accept at that level. And again, slightly self-serving, but engage with external lawyers who can obviously help and assess certainly the merits of settlement offers. And the last one actually is quite possibly one of the most important ones so far as in-house lawyers are concerned. Obviously, while potentially obvious, involve obviously the key business leaders in settlement discussions, ensure that they're aligned, ensure that it's in step with the company's objectives, and if nothing else, get buy-in. Obviously, I've spoken about what a burden external lawyers are, but it's not lost on me that in-house lawyers are often there getting in the neck from senior execs saying, well, make this litigation, sorry, there we go, seamless, making this litigation go away and ultimately creating a cost which the company would otherwise want to avoid. Yeah, that's what we can really sound it. So you have my sympathies as well. And the last slide, and again, I said, That's gone orange. Is that okay? Okay, fine. Yeah, thumbs up at the back. Thank you. Right, without wishing to sound glib or more glib, final slide is obviously choosing about the right lawyers. Doesn't necessarily mean attaching a well-known firm or necessarily a firm you've instructed before now, but selecting lawyers on the basis that they have the right expertise, the right competence and an approach which aligns with your with your needs and values. Not just that, but at a human level, can you see yourself working with the lawyer? Are they going to annoy you? I mean, it's going to be sort of often fairly stressful, time-critical situations. How do you sort of rub along? Certainly for my part, when instructing counsel, I want someone that's going to take work off my desk, make my life easier, not create too many sort of barriers to getting the work done, and actually being good to deal with and available at all times. And again, no one size fits all. People have different ideas, and I accept that one person may not be for another. So again, it's stolen my march slightly here on the screen, but obviously identifying key criteria for selecting externals. Amongst those things that I've listed there, consider recommendations from peers in the industry, and albeit with a healthy pinch of salt, see what the directories say and do your research. Secondly, establish clear guidelines, whether it's in terms of billing or communications and case management from the outset. Within reason, as the client, it's in your gift to set out early doors what it is you want. And then the last one, regular meetings. And as I said, I accept that you have very busy days, and so you'd rather not be engaged on calls or meetings if avoidable with your externals, but certainly that's something to, I think it's perfectly reasonable to expect. And while not strictly connected to a sort of litigation process, if you are sending a lot of work to those externals, I think it's well within your remit to ask for in-house training for materials and further support anything that makes your job easier. As I said, let's be honest, there are a lot of lawyers out there who'd be really hungry for your work, so make us work for it. I'm making a rod for other people's backs by saying that. And with that in mind, I'm pleased to say, for all our sakes, that brings my part of the discussion. Obviously, will be available at the end or afterwards to pick up any calls. And with that, delighted to pass you to Victoria and my employment team. Thanks. I wouldn't knock that over.
Thanks. Morning, everyone. There is a lot going on in the employment space at the moment, so there's a lot of ground for me to cover today. So I'm going to focus on giving you a high-level overview that I think in-house lawyers should be aware of and flagging to their businesses. I'm conscious I've only got 15-20 minutes, so I'm going to keep it focused on the key points. And in a lot of cases, we're facing the biggest shake-up in employment rights in a generation under this Labour government. And in a lot of cases, we've got the upcoming employment rights bill that we know is coming, but we're waiting for further regulations that will set out further details. So I'll be flagging the key changes that are coming, but in a lot of cases, I'll be saying we're waiting for the detail about how that's actually going to be implemented in practice. So I've got up on the slide the areas we're going to talk about today, and they break into three areas roughly. We'll start with looking at the changes in collective employment law. No surprise for a Labour government that trade union reform has been high up on the agenda. And then we'll tend to look at some changes in individual employment rights before finishing with looking at some developments in equality and equal pay legislation, and also the recent For Women Scotland decision. So turning first to the trade union reforms. This has always been a clear commitment from Labour from the outset, and the Employment Rights Bill essentially seeks to facilitate increased trade union membership in a couple of key ways. Firstly, they are going to increase or give trade union officials a wider right of access to workplaces. So currently there is no general right of access for trade unions to workplaces. they generally have that access where they're recognised as a trade union and they've agreed those arrangements with the business. But the bill will give them the right to request that access, and there'll be a statutory process that needs to be followed in relation to those requests. So the business can choose whether to agree to that request and negotiate the terms of the access. And if that can't be agreed, there's a route for them to apply to the arbitration committee for an order requiring that access. So that could potentially open up businesses to more trade union activity than they have been used to. The second requirement is to require employers to inform their workers that they have the right to trade union membership. And that will be a requirement to inform them at the same time that the usual Section 1 statement of employment terms and conditions goes out. We don't yet have the detail about exactly what they need to be told in the format. We're waiting for further regulations in relation to that. So we'll need to wait for further details on that. The other key change in this area is going to be lowering the thresholds for the statutory trade union recognition process. Anybody who's had the misfortune to look at the current rules will know that they're really complex. So I'm not going to spend a lot of time explaining the intricate details of the current process and how it's going to change. See what you mean? But the key takeaway for businesses is that the bill is going to meaningfully lower the thresholds for trade unions to be able to seek statutory recognition within workplaces. And the final point on the slide then is also mentioning that the bill is going to ease some of the requirements on trade unions in relation to industrial action. So, for example, the legislation that gives the government to set minimum service levels for essential services is going to be repealed. And most of the Trade Union Act 2016, which placed various restrictions on strikes, including the requirement for longer notice periods on unions and limitations on picketing, most of that will also be repealed. The bill is also going to extend the expiry for the mandate for industrial action. So it's going to extend the current limit from 6 months to 12 months. And it's also going to reduce the notice periods that's required from trade unions for industrial action. So it's going to reduce that from 14 days to 10 days. The government has also said that it intends to introduce electronic balloting and is launching a working group with stakeholders in relation to that. And we're expecting some new regulations in relation to that next year. But in summary, effectively, all these changes are going to roll back pretty much all of the changes that were brought in by the previous Conservative-led government since 2010. So it is a big change in this space in relation to trade union activity. So I think what businesses need to be thinking about, particularly those that don't have a trade union presence at the moment, is steps they can be doing to improve their employee relations within the workplace, thinking about whether they can do anything to improve employee engagement, for example, employee forums, so that workforces are less receptive to approaches from trade unions. Although I think it remains to be seen whether the trade unions are going to have the resources to sort of make really extensive inroads into lots of different workplaces. We will have to see. So moving then on to the proposed changes in relation to collective redundancies. So as a quick reminder, the current law is that where an employer is proposing to make redundancies of 20 or more dismissals at one establishment within a period of 90 days or less, they need to consult with elected representatives of the affected employees. The proposed change now with the bill is to introduce a new threshold figure as an alternative trigger for those collective consultation obligations. We're awaiting the definition of the new threshold test, but it will involve counting proposed redundancies across the whole of the employing entity, regardless of location. And although we don't yet know the number for the new threshold, it's understood that it won't be less than 20 and is likely going to be a number between 20 and 100, or it could be a percentage test. So, for example, it could be the lower of 100 or 10% of the workforce across the employing company. As it says on the slide there, there's going to be no change to the periods of collective consultation, so they remain as set out on the slide. But there is going to be a change to the compensation that can be claimed, which is known as a protective award. So at the moment, the protective award is up to 90 days gross pay per employee, which actually can already tot up to quite a significant amount given the collective context in which it's awarded. What the bill is going to do is to double that award, so to increase it to 180 days gross pay per employee. But if some relief, at least to businesses, is that the government's proposal to actually make that an uncapped award and also to allow interim relief applications for these types of claims have been dropped at least. We don't yet know when these changes are going to be coming in, and the government still needs to define the new threshold test. And so I think we're looking more likely that it will be next year before these changes actually come into effect. But I think it's something that businesses should be aware of and factoring in now in relation to restructuring proposals that they're thinking about, because it is going to draw in potentially a lot more redundancy processes to the collective regime than has previously been the case. I mentioned for completeness just the bottom note on the slide, because these practices can often come up in a collective context. So Labour had initially said that they were going to end the practice of fire and rehire and fire and replace. Fire and rehire is a means of lawfully changing an employee's terms and conditions. And fire and replace is where a new workforce is engaged to replace an old one on more favourable terms to the employer. And it was a key election promise from Labour as part of their manifesto that they were going to tackle this. And it follows a lot of high-profile cases where these practices have received very adverse publicity. So, for example, you might recall the P&O Ferries case where they dismissed around 800 employees to engage lower-paid agency staff. So, despite Labour's promises, actually, the bill won't eliminate this entirely, but it is going to severely limit the circumstances in which employers can use this as an approach. So the bill is going to make it automatically unfair to dismiss an employee for refusing to agree to a variation to their contract. And it's also going to be automatically unfair to employ another person or re-engage the same employee under a varied contract to do the same or substantially the same duties. But there will be an exception where the employer can show that the contractual variation was to eliminate, prevent or significantly reduce or mitigate financial difficulties. But the bar is set really high for those financial difficulties because they have to show that at the time it was affecting them or was likely to in the immediate future affect their ability to carry on the business as a going concern or otherwise carry it on. And they also need to show that the contractual change could not reasonably be avoided. So I think the bar is set quite high. The full scope of the new provisions remains to be seen, and time will tell how restrictively the tribunals are actually going to interpret this exception. But I think it's expected that the exception will apply only in very limited circumstances. So moving on now to a significant change in relation to individual employment rights. So the law at the moment is that employees have to have 2 years service to bring an unfair dismissal claim unless they've got grounds for an automatic unfair dismissal claim. And what the bill is going to do is to make that a day one right for employees. And it's also going to introduce a concept of a new initial period of employment, an IPE, which will come with modified rights. And that will require an employer to follow a light touch dismissal procedure during that IPE. The duration of the IPE isn't actually specified yet in the bill, so we don't know how long that's going to be. It's going to be set out in separate regulations, which the government has said they will consult on. They've initially said their preference would be for it to be 9 months, but we'll have to wait and see. We also don't yet know what the light touch dismissal procedures will be. They're also going to be set out in regulations. But as a starting point, the government has suggested that they would be looking for there to be a meeting held with the employee to explain the concerns, at which they could be accompanied if they wished. There's no yet mention of a requirement to set anything out in writing, but we'd recommend that in any event as good practice. The modified approach dismissal process will apply where the dismissal reason relates to the employee. So, for example, where it's due to their performance, capability, conduct, or some other substantial reason relating to them. The latter would include, for example, if there's been a breakdown in the working relationship or, excuse me, a customer is refusing to work with the employee. But what it won't cover is restructuring, so where the employee is made redundant, or where, say, a fixed term contract has not been renewed because they're covering family leave of another employee, because those reasons don't relate to the employee. And the government have said that prior to publishing the regulations on this, they're going to consult on these reforms, including the length of the IPE and the light touch dismissal procedures. They're also going to consult on the compensation regime for this, including in relation to what should apply during the IPE period, which suggests they're considering whether a lower level of compensation should be awarded during that initial period. But we'll have to wait and see the outcome of the consultation in relation to that. The key thing to be aware of is actually they have confirmed that these changes aren't going to come into effect until next autumn. So the 2-year qualifying period for unfair dismissal claims is around for a while longer, and we'll have to wait and see what the approach is following the consultation into how the IPE and compensation regime will work. So moving on to flexible working, it's been a day one right since last April for employees to have a right to request flexible working, and an employer can refuse such a request on one of the 8 specified business grounds that are set out in the legislation, although there is an obligation currently on employers to consult where that request is not going to be granted in full. What the bill is going to do is to introduce a test of reasonableness to employers' decisions in relation to these requests. So it will make it harder for an employer to refuse a request, because they will only be able to do so where both the employer considers the application should be refused on one of the 8 permitted grounds and it's reasonable for them to do so. And in addition, if they do refuse the request, the communication of that decision will have to both state the reason or reasons that they're relying upon, and also why the employer considers it's reasonable to do so. And the bill will also require certain steps to be taken in relation to the consultation on the request as well. Unfortunately, we haven't got the detail on that. That's going to be set out in further regulations, so we'll have to wait for some more clarity on that. I think this is likely to result in more tribunal claims from employees in relation to these requests where they're refused, because it gives employees more scope to challenge the employer's decision given the introduction of the requirement for reasonableness. But it's worth noting that there's actually no change to the compensation for these claims, so that remains at 8 weeks' pay. So query whether it really has any financial teeth in terms of the level of claims and the value of them to businesses. Finally, just to flag the final point there, that the government has dropped its proposals around introducing a right to disconnect for employees, so that's not going to go any further. So turning to the prevention of sexual harassment, these changes came in October of last year, and this brought in an anticipatory duty for employers to take reasonable steps to prevent workplace sexual harassment. And that's a positive and proactive duty on employers to prevent harassment before it starts. So as part of this, it's important for businesses to have a clear policy in relation to this, to be undertaking risk assessments, implementing training and monitoring how they're complying with this duty. But the key point to flag to businesses is this isn't a one-off tick box exercise. The duty requires this to be a regular, ongoing review that businesses are taking in relation to this. In terms of enforcement, there are 2 potential routes. The first is for an individual employee to bring a tribunal claim for workplace sexual harassment. And where those claims are upheld, the tribunal can uplift compensation by up to 25% to reflect the extent of any breach by the employer of this duty. The second route for enforcement is through the Equality and Human Rights Commission, and the scope for enforcement here against businesses is wider. because the Commission can take enforcement action even where there's no actual harassment or there's been no claim or complaint by employees, and their powers are quite wide-ranging. So they can conduct investigations into workplaces, they can seek agreement with businesses as to plans they're going to put in place to address any issues. They can also intervene in litigation. Because of the delays in the tribunal system at the moment, I think it's going to be a while before we get any case law guidance on what steps an employer would reasonably be expected to take here. But the Commission has already taken some enforcement action, which gives us some insight into the steps that an employer might be expected to take in this area. And a lot of what they've said is what you'd expect, so around training and education of employees. But there have been some other interesting indications about the direction of travel here. So, for example, in the Welsh Rugby Union case, that included them being required to review their use of NDAs. It also interestingly required an EDI strategy to be implemented across the business with a 5-year plan, with senior execs having specific individual performance objectives linked to that plan being achieved. In terms of proposed amendments, as part of the bill, the first step is that employers are not just going to be required to take reasonable steps to prevent workplace sexual harassment, they will be required to take all reasonable steps to prevent that harassment. So it is increasing the requirement on employers further. And there will be regulations that will be provided for that will explain what all reasonable steps might mean. And there's going to be a consultation about that. So we'll have to wait for further information about the expectations on businesses in relation to this. So finally on this section, I'm just going to look at the changes on third-party harassment. So some of you may remember that the original version of the Equality Act made employers liable for the harassment of workers by third parties, and that was repealed in 2013. And the Labour government is going to bring that back in with a bit more bite this time. So the proposal now is that a single act of harassment would render an employer liable for that harassment. And in this case, harassment includes harassment on the grounds of any protected characteristic, so not just sexual harassment. And similarly, as we've just been discussing, the employer will not be liable where they have taken all reasonable steps to prevent that harassment taking place. I'm conscious of time, so I will try and whiz through these final 2 slides quite quickly. So since 2017, organisations with 250 or more employees have been required to publish gender pay gap information. Under the bill that's coming, those employers will have to develop equality action plans showing what steps they are taking in relation to prescribed matters relating to gender equality. And that will include the measures they're taking to address their gender pay gap. And they'll also have to publish prescribed information relating to their plans. You have guessed it, we are awaiting regulations in relation to the detail of what's required there. So this is just a heads up that this is coming. Similarly, the bill is also going to amend the Equality Act to require employers to provide information about the service providers that they contract with for outsourced services. Again, the detail will be included in regulations, but the intention is to ensure that organisations are held accountable for the pay gaps that exist in companies that they use for outsourcing and motivate them to support and drive changes within those organisations that they're linked to. And separately, just to flag that there's going to be changes in relation to pay gap reporting in relation to ethnic minorities and disabled people. The draft for that has not been published yet. But the intention is to introduce mandatory ethnicity and disability pay gap reporting for employers with 250 or more employees. And a consultation started on how to introduce that pay gap reporting in March of this year. So it's not anticipated that we're going to see any changes until at least next year in relation to that. And then finally, I couldn't do an update session without at least briefly mentioning the recent very high-profile Supreme Court decision in the For Women Scotland case. As you'll probably have seen, it has triggered a lot of very public and, in some cases, quite polarised debate. The decision itself was about a very narrow point legally. It was about how the Equality Act should be interpreted, specifically how sex and woman should be interpreted. And the Supreme Court said that that should be given its biological meaning. A lot of the subsequent debate around the decision has focused on the implications of that decision, the wider implications, and what it means in practice in various areas. And there's been a lot of discussion about what it means for the use of single-sex spaces, in particular toilets and changing rooms. The EHRC is working to update its statutory and non-statutory guidance following the decision, and a public consultation is underway at the moment on the statutory services code of practice. That was launched last month. They've extended the consultation period until the end of June, but I think that's going to be extended further because I've seen there's been various legal challenges about that. They haven't yet confirmed the timeline for them to update the employment code of practice. But in the meantime, they have issued a short interim update highlighting what they consider to be the main consequences of the decision. So I flag this as something that businesses should be thinking about if they haven't already, and also as something to keep an eye on, because I think it's going to be a key area where there's going to be some significant developments in the coming months and probably years in relation to the balancing of transgender rights and other protected characteristics in the workplace. And that brings to a conclusion my section.
Right, thank you, Victoria, Sven and Richard. A lot of information there with a lot of practical guidance, so thank you all. Now, opening it up to the floor for any questions, we can probably squeeze a couple because I know we're just running short of time. Does anybody have any questions? Yep. So that was, sorry, just to repeat the question for online. So the City Fibre case, is that likely to be appealed? I don't know if you want to come here and answer, just though the online.
I can only answer briefly. I would need to find that out for you. But yeah, there's no reason why it couldn't be appealed. I'm just not aware of any plans for it to be so.
Anybody else? Okay, I've got a few, but I'll fire them over, and we can add them onto the questions when we send the slides and the video back. So thanks for all for coming and those joining online, and to our speakers, and obviously to our sponsors Hayes. Hopefully there's some takeaways for everybody, and for those here in person, you've had the opportunity to network, meet other professionals and meet members of the Myerson team.